Okay, we are recording.
All right. Thank you, everybody, for being here, especially folks I just saw in the previous meeting. It is January 12th. It is 7 p.m. This is a Building and Housing Committee meeting, City of University Heights, and we have Mr. Rock and Ms. Pardee, Mrs. Weiss, Mayor Brennan, Law Director McConville, Mr. Brendan Zach, and Susan Druck. I think I've got everybody. Our first item, I believe, is our revisit of the ordinance amending codified ordinance section 1280.10 entitled rental of 1 and 2 family dwelling units in U1 and U2 districts. I believe everybody's received the pieces from Mr. McConville, his memorandum of January 7th outlining the most recent suggested changes to this piece of legislation. And before we discuss, I'll turn it over to Mr. McConville and let him outline what this is going to entail.
Sure. I was just thinking that if I was being paid by the hour for the rental registration ordinance, I could view it as like an annuity in any event. I was asked by
with annual returns
by council members in light of the ACAR letter, the letter from the Akron Cleveland Association of Realtors. That was in its tone, I think, a little threatening, to take another look at these issues. And as I read through the Bowling Green opinion several more times, I just became uneasy about a few different pieces of the analysis that the court set forth that really were sort of apples to apples in terms of the Bowling Green ordinance when you compared it to the University Heights ordinance. And in particular, the court was bothered in that case by the idea that an unlimited number of related people could live in a home, but only 3 or fewer unrelated people could live in the home. And it was really that that fact that I think drove the court to determine that the ordinance was both arbitrary on the one hand and overly broad on the other. So that was the sort of factual aspect that bothered me. And then, a close reading of the Belterra case, which is the U.S. Supreme Court case that gave me comfort, revealed to me, and perhaps I should have caught this the first time through, but revealed to me that the court used a rational basis standard, which is the lowest form of standard that you can use in a constitutional case. And so the standard of review that the court was using in the United States Supreme Court case was different from the standard of review being used in the Ohio case, because in the Ohio case, there's jurisprudence that's grown out of the Equal Protection Clause that indicates that real property cases are to get heightened scrutiny. So basically, we provide under the Ohio Constitution some greater protections in real property cases under the Equal Protection Clause than the federal government provides under the Equal Protection Clause of the federal Constitution. And so that's sort of a technical issue, but was another that was instrumental, I guess, in modifying my legal opinion. And then lastly, and not insignificantly, is I had multiple conversations with my partner, Mike Cicero, about this case and about our ordinance. And Mike, as you know, is general counsel for Norma, who is our insurance carrier. And Mike expressed a concern that the carrier might look at the um, Bowling Green opinion and the difference between the Ohio Constitution and the federal Constitution, and conclude that we were sort of willfully ignoring applicable law in Ohio, and that willful ignorance or intentional ignorance of new case law could present a coverage issue if there was a case that presented possibility of money damages. Secondarily, he thought, if we're in an eminent domain setting, a landlord is alleging a taking of his property by virtue of not being able to rent it, then we're uncovered no matter what. Norma doesn't cover those kinds of cases. That's sort of a new avenue that plaintiffs' lawyers are using apparently to attack these kinds of ordinances. And so we really want to take whatever steps we can to avoid litigation in the first place. And so that's another consideration in terms of making changes to the ordinance. Lastly, I did have some conversation with Colleen Trummel over at John Carroll. She's John Carroll's general counsel. I provided these latest suggested changes to the ordinance to her as a professional courtesy, because John Carroll has been outspoken in their desire not to have these provisions change. She had indicated to me that she wanted to kind of take a look at it, take another pass through Bowling Green and see if she had any comments. I have not received any comments from her, but I think it may be worthwhile to engage John Carroll in that way, just to see what they have to say, if anything. Well, let me leave it at that for now. I would, I guess, ask for your feedback.
So on this ordinance, everything in red here is what has been changed since when? Since we last spoke, or is this all the changes
Oh, so
from prior meetings?
what the ordinance is redlined to show all of the changes we've made, and then I highlighted in yellow the changes that I've made since our last meeting.
Okay, so for example, then in section 1280.1, section 2, you're removing the portion about the 3 unrelated people, and instead is including a description here that the number of people does not exceed the number of bedrooms. So if I have an 8-bedroom house, I can have 8 unrelated people. Is that correct?
That would be correct. That is the space-based regulation that was recommended by the court in Bowling Green. So one of the things we're trying to do here is then narrow the definition of bedroom under the auspices of health and safety by saying that a bedroom would be a room that had direct access to a full bathroom located on the same floor without the need of traversing through another room. So if you have, a home where there's a central hallway and a full bath off that hallway, you're not going to impact the analysis of the number of bedrooms. But if you have a home that has Jack and Jill bedrooms, as some homes in University Heights do, or if you have a scenario that, for example, exists in my home where you have a master bathroom that's accessible only through the master bedroom, and then a second full bath on the second floor that's located in between 2 bedrooms, and then a fourth bedroom that exists, but with respect to which you would have to either go through the master bedroom or go through one of the other two bedrooms to reach it. For purposes of the calculation under this ordinance, you would have a 3-bedroom home.
Okay, so, well, first, I'll just preface by saying I remember, I don't know if it's this council from the prior council. I know there was deep uncomfort in having more than 3 unrelated people. So I'm already, I guess, turned off by this. And I understand what you're saying. And I understand the premise of this regarding the Bowling Green case. However, we could go a step further in limiting the number of bedrooms. You know, some banks say you have to have a closet in the room. You have to have a window. It has to be, an egress window. It has to meet a certain square footage. Because there are houses in University Heights where the basements have been turned into 2 to 3 bedrooms with maybe no accessible way out. And so it is possible where you can have a 6-7 bedroom house here in University Heights. What about somebody who puts on like an addition to the back of their home for the purpose of it being a study, and then later someone transforms that into a bedroom? Because if I'm a landlord and I know, well, I can get a 4th tenant in here, I'll just turn that library into a bedroom.
But doesn't Luke say that you would have to not pass through those other rooms to get to a bathroom?
But when you say pass through rooms, are you talking about passing through another bedroom or another room that's programmed on the first floor? Like, can I pass through the kitchen? Can I pass through a family room?
No.
Okay, so if it abuts a family room, then you're saying you're passing through a room. Is that correct?
Yeah.
Mhm.
Yes.
So you're saying only if there's a bathroom with a hallway, that would be acceptable.
Either a hallway or directly connected.
We're directly connected, right?
Yeah. But you can't be traveling through other rooms to access it.
Right.
And we limit 3rd floor bedrooms.
Well,
Well, third floor bedrooms will not be counted unless they have an attached, bath, unless they have a bath up in the 3rd floor.
Full bath.
so I mean,
Because it has to be on the same floor.
basically this is undoing everything that we have stuck to our guns with the 3 unrelated people, because
Well-
many houses have a minimum of 4 bedrooms here.
I mean, there's one other possible approach, and there's one other possible approach. If you look at the language of the opinion, and delve into it, into the sort of guts of it, there's language in here where the court is complaining about the ordinance, and they say, the dwelling limit sweeps far more broadly than just
I
to
think
avoid purported
there's-
problems with college-age renters. The
Whoever
dwelling limit prohibits any 4 unrelated individuals, regardless of their propensity to cause disturbances. And the city does not explain why prohibiting more than 3 college-age renters from living together prevents these issues. What's interesting to me about the language is that, if you read that first sentence again, the dwelling limit sweeps far more broadly than just to avoid purported problems with college-age renters. You could say, okay, well, what if we just specifically limited unrelated college-age renters and defined college-age renters as being people between, the ages of 18 and 23. You don't have an age discrimination issue there because age discrimination relates to people who are above the age of 40.
You guys like it?
at the controls, could you mute?
I'm
thank you.
trying to get them all kicked off now that
I mean, it is an open meeting.
well, hold on, I didn't do a waiting room because before, but I think we'll do it. I mean, it's
Mhm.
there. I mean, but the thing is, just so everyone's aware, if someone comes in the waiting room, it's a public meeting,
Right.
just so we're aware.
Mhm.
Yeah.
Okay.
Oh.
Thank you for taking care of that quickly.
So anyway, you could kind of go in the opposite direction, specifically targeting college-age renters, and I think at least be able to argue with a straight face that you were complying with the specific language in the Bowling Green case, and on that basis, preserve coverage. Whether a court would favor that kind of regulation and find that there was justification for it is another question. Obviously, we could present arguments about, anecdotal history in the city, evidence of, police activity among college rented homes. Certainly, we have that kind of evidence where we could try to argue that a regulation like that should survive, heightened scrutiny. I'm not exactly comfortable that it would. I haven't seen any other college towns with that particular type of regulation, but I do think it would allow us to present a pretty good argument to the insurance company that we were looking specifically at language in the opinion and trying to work with it to maintain this provision. It's not as clear to me legally that that's sustainable as, the approach that I've put in the suggested language in the ordinance, but I am very mindful of the fact that this is going to create heartburn for people, including my neighbors, in the city, when they learn that the three unrelated, provision has been, removed.
Can we add what John said, that it needs a suitable closet and proper egress?
Yeah, I think those things,
Because that's just safety and security. I mean, that's the rule regardless of whether or not you're looking at, bedrooms have to have a window that provides egress or another form of egress. That's not unreasonable. That's code.
Well, and just so everyone's aware, and I don't have a page number here, but on, under
What section?
it's under number, rental permit application.
Mhm.
So number 2, letter D, there it talks about, Councilman Rock, you were asking about minimum square footage that is listed in there. Luke has it in there. And then also that bedrooms in the basement are prohibited as well. So, so there are some of those restrictions. As far as the windows, though, I don't know about that, Luke. I was trying to read through to see if there was.
Yeah,
I think closet space is a legitimate
Mhm.
Issue too,
Yeah,
because
yeah.
you can envision someone piling up whatever they're going to pile up, whether it's clothes or
Yeah.
Suitcases or trunks,
Boxes.
whatever they own, I guess.
well, it is a traditional feature of American bedrooms in particular that it would have a dedicated closet. And I don't think that would be an unusual feature here. I think we could add that. I think, there are other places in our code that specify that a bedroom must have windows and that a
Mhm.
bedroom cannot be in the basement. So whether it's already in this section or whether we want to cross-reference those
Yes.
sections. That that may provide some clarity for folks who would look at this section and look at it with blinders. You know, you can't just turn your dining room into a basement. You can't just turn the bonus room on the back of your house, or I'm sorry, not basement. You can't just turn your dining room into a bedroom. You can't just turn your bonus room on the back of your dining room into a bedroom. You can't take the large bedroom upstairs, put in a dividing wall, make it 2 bedrooms because you're not going to have enough square footage. I think there are very few ways to work around in the ways that we may be concerned about. And there are other things, and this is something I think we can stress to the residents. There are other things we can do to ensure that properties are not overburdened. We can make sure that we are enforcing that cars are not parked over sidewalks, that they're not parked on the grass, et cetera, et cetera. And the thing is if you try to put too many people into a home, inevitably you have too many vehicles parked there. And that is something we do ticket, and it's something that we can make a point of ticketing more, except that, you know, we tend to ticket it when we see it. So.
And I believe Luke has that in there about the parking not being, you know, over the sidewalk or not too many cars to fit in the, you know, the property's driveway.
Where's that at? Luke, can we limit the number of cars if it's a rental?
Well, some houses have very short driveways and some houses like mine have a very, very long driveway.
Well, the issue is when you have a 5-bedroom house and you have 5 cars.
Yeah.
That's gonna be the
Yeah.
issue. Because
So if we can limit the number of cars, we would limit the number of people.
5-bedroom houses here.
Right, but you also have, I mean, I don't know how, you know, to what extent this would be true in the rental market, but you do have families that have 4 and 5 cars where they have kids who are older.
That's true.
Of course,
That was mine at one point.
That would not be applicable in a non-rental.
Right.
But if we're also talking about equal protection, you know, if we're treating rentals differently than residences on this, in this regard, could run into some trouble, I think, couldn't we?
Well, you're going to have to survive that heightened level of scrutiny.
Mhm.
So it's going to have to be, you know, related in some way. You know, if you've studied constitutional law jurisprudence, these terms mean a lot. If you haven't, it's hard to describe exactly what they mean. Rational basis is a rational relation, you know, to a specific legitimate purpose, so health and safety. Strict scrutiny is a very narrowly tailored, specific regulation designed to meet a very particular interest. What the court in Bowling Green says is that the Ohio Constitution mandates somewhere between rational basis and strict scrutiny. So it's not exactly a bright line test that they're articulating for lawyers and anyone else who wants to analyze what's required. But it is heightened scrutiny. It's more than rational basis. That's what we know. And so we don't want to be sweeping with a broad brush because the court will presumably not, a court will find that to violate the Ohio Equal Protection Clause in the real property context.
Well, I mean, I guess at this point, we've tightened everything up as much as we can, right? So we're going to, you know, we did all the other things in terms of when we're inspecting, we raised the cost a little bit. Our form shows names on it now. You know, the building department's going to have to be really, really on top of the renters now. So, you know, now we added closets and egress. So I think our hands are kind of tied with anything else, unless anyone else has any ideas.
I think Luke's suggestions have put us in about the best spot as we can be in light of the Bowling Green case.
Yeah.
Well, let me, I mean, the one other thing that might be worth studying is whether there's some other rationale for like establishing a minimum square footage for.
You just don't want to run afoul of that whole insurance thing either.
Well, the insurance issue is, as I said, I think it's a significant issue. I wouldn't have mentioned it in my memo if it weren't.
Mhm.
I think it's also worth it just to see if I can nudge Colleen Trummel at John Carroll again for any thoughts she may have. I mean, there's no, review by another lawyer is
Another set of eyes.
another set of eyes. But I can add specific language relating to closets and egress.
It's for everybody's security, everybody's health and welfare, whether they live in the house or their neighbors.
And, depending whether I hear from Colleen or not, I mean, I could perhaps report out at the next council meeting what, if any, comments she's offered. And perhaps recirculate another draft. And if you want to have another committee meeting, we can, or you can, indicate that it's ready to go onto the agenda.
I'd be here to see what Ms. Trammell had to add, if anything. The fact that she didn't come right back to you, I mean, she may be busy, but maybe it's none of it is egregious in her eyes.
Well, we did discuss it. I mean, she thought, she started going down the road of maybe there were some factual distinctions because the Bowling Green case involved a fraternity, but the court really doesn't get into that at all. They don't care that it's a fraternity or not. They just care that the three unrelated provision is arbitrary. It's limiting the number of unrelated people where there's no limitation at all on the number of related people. I mean, I can read the examples that they go through. While the dwelling limit does not forbid an unlimited number of related adults from dwelling together in a 4-bedroom home, assuming compliance with the regulations, just 4 unrelated adults may not do the same. Under the dwelling limit, again, assuming compliance with health regulations, 10 related individuals could reside in a 2-bedroom home with no parking, while only 3 unrelated individuals may reside in a 6-bedroom home with abundant parking. So that's what offended the court.
I say, talk to Colleen Trammell. And I think before we discuss it on the floor, maybe send us another memo that, lets us know what that conversation consisted of, and if we're still in the same place we are now with the tweaks we've come up with this evening, or if we need to even explore this even further to take the things that she may have into consideration. What does everyone think?
All right, and I'll at the same time, I'll distribute a slightly updated version that includes the further limitations that we discussed tonight.
Right.
The closet
Right.
and yes.
Any additional thoughts?
one thing in the that's being changed in this ordinance is the inspections are still every other year, but they will have to register every year.
Mhm.
Franklin cannot handle this. So, I fully agree with Luke's opinion on, following the court case from Bowling Green, but the permit duration cannot change while we're still on Franklin. It's impossible to track. Franklin is discontinued and does not have service, so it can't be changed. Once we're on Citizen Serve, it's tailored to our ordinances and how we track and do everything. So that's something we can do, but it's just frankly something the department cannot handle at this point.
Right. Brandon, how are the two new administrative assistants doing in learning the system?
So the system is not built yet. No one is learning it. No one is on it. The system, it's not like buying Microsoft Office, installing it on your computer, and then,
It's
putting your name in
customized.
and it's
It's
ready.
customized to what we do.
Yes, it's customized.
Okay.
Every single aspect is customized to
Okay.
the city's ordinances, but from building, housing, everything. I mean, we're going to do BZA planning and ARB through it, and it's just, it's going to take a while for this to be ready. Especially with new people learning what we have now, it's going to take months before we're ready for this.
Susan and Brendan, what do you think is a realistic guesstimate with an ETA to have this up and running?
I think 6 months would be a reasonable time. Because after we build the system, there's going to be weeks of training, then there's going to be weeks of scrubbing the data from the old system to ensure that we're importing everything, and then weeks of scanning all of our paper documents into the system, all of our active paper documents. Because even though we have Franklin, the building department is still half on a paper system. So we can't start scanning the the rental reports or the point of sale reports and now, because by the time the system's ready, they'll be 6 months out of date and we'll have to redo it again.
Luke, how would you suggest we even phrase a delay in the change?
Well, can't you just, isn't this something though, that if it was passed, you say to become effective on such and such a date?
That's why I'm asking, what do you think?
Yeah, because then if you could,
timeframe's gonna be?
it's not that, the only problem is that, again, the two new people are very eager to simplify the processes in the building department, because Franklin is so labor intensive, it's ridiculous. But the only holdback though too is as Brendan's right now working with the company to get this built out, a lot of that's delayed because he's pretty much standing over the two assistants, because everything is so labor intensive. He has to guide them step by step. And for every kind of permit, it's a different sequence that you go through Franklin for every permit, every re-inspection, all the money taken.
And yet we're still having to continue to use it, even though there isn't. Did you say support for it?
Right now.
Yeah.
Mm-hmm.
You have to use Franklin until you can't any longer, but that's why we want to get out of it sooner than later. But it holds Brendan up because he's really consumed by training them, and rather than, because when it goes to import, and Brendan, correct me if I'm wrong, it's not a clean export from Franklin and importing into Citizen Serve, and that's when the two of us were going to sit down and go through every single parcel then, because we have to make sure the upload was correct as far as parcels, ownership, addresses, all of that.
Yeah, especially because in our system, some commercial properties, every single address is a different instance in the system, whereas other properties, it's the entire building as one address with, nothing is consistent in our current system. So as Susan was saying, every single part, all 4,200 and some parcels in the city will need to be looked at before we can even get them in the system.
Can we bring in a temp or something to get this?
Expedite this?
Citizens serve for almost 4 years at this point.
I don't know, about 4 years. Patrick was starting to implement it. He did get pushback from the staff at that time and the former building official. So that caused a big.
Whatever it is, we're here right now, right? So.
Right, then that's asking Brendan to train another person to do something. It doesn't help. It's easier if Brendan and I do it than to sit there and tell someone, okay, well, this is how Franklin works, so then this is how Citizen will work.
Although certainly some portions of the process probably could be done by temp, like you had mentioned, and correct me if I'm wrong, like having to scan documents in.
Sure.
Yeah, I mean, because that's labor intensive. That takes all sorts of time when people who have other knowledge, skills, and abilities can be focused on the bigger picture.
Absolutely. And one thing that Patrick brought up when he was still here was hiring a company that has the the scan to text capabilities.
Yeah.
So we can search through these documents to make any public records request, anything easier and less labor intensive for the department.
So I guess I'm circling back to you're thinking 6 months. Do we put a date in here to become effective? Poor Lucas. I'm watching you rub your head.
I was thinking, we would want the provisions of the ordinance that don't relate to, I guess, registration in particular. Because inspection is unimpacted by that, right? Because we're just doing it once every 2 years anyway. That's the same as we have it now.
Correct.
And if I'm thinking about this correctly, you have a certain number of landlords who come in 1 year and then a different set of landlords come in the next. So you're sort of every year issuing 2-year permits so that you kind of flip-flop who you're dealing with. So the implementation of the fee schedule is also problematic because it's going to cut your revenue in half.
And right now, so everyone knows, right now, there's approximately 500 rental inspections per year going on right now, the way it's set up. Correct, Brendan?
There's about 500 units. I believe this year there were 750 individual inspections.
Well,
'Cause some units need
inspection too.
Yes, that's including re-inspections.
But I just meant initially.
Yes. Yeah, we average 400 to 500 a year initial.
So the desire is to maintain the current schedule for both registration and inspection. For what are we talking about? Another year or 6 months?
That's what I'm trying to get to.
Is this something that we could reintroduce when we know Citizen Serve is just about ready? So we're not, legislating a certain date?
I think there's some things we probably want to have changed now, and maybe we put an effective date of August 1st, August 15th, something. And then we revisit that date when we're closer to it as to whether that date is still realistic or if we need to adjust it further. I guess August is slightly more than 6 months.
Are you talking about the ordinance in toto, Michael?
No, I'm talking about the parts that are affected by the Franklin Citizen Serve changeover.
Okay.
Yeah, I mean, the part where we're talking about changing, fee structure and frequency of inspection or frequency of registration. But when we're talking about the alteration to what constitutes a bedroom and things like that, those aren't things that are affected. That Franklin Citizen Serve changeover has no impact on that, I don't think.
Just so everyone knows, there's people entering. I'm just gonna keep them in the waiting room. Is
Yeah.
everyone okay with me doing
Yeah.
that? Okay.
Yeah,
Luke, can we do that?
Just don't wanna, I mean, I know it's a public meeting, but
I think you can message them in the waiting room and you can ask
Yeah.
them to state their business.
I would
Okay.
prefer that just because if someone is there because they have a rental unit,
Yeah.
that's it. That's why I let the others, I was waiting to see, so.
But yes, state your name and address.
And
Yeah,
then if they-
Justin has a method of,
Yeah, because I'm only getting the admit and remove, and I'm sorry to interrupt the meeting for this, but I just wanted people to be aware.
Right.
If you can limit people's ability to unmute themselves and just make an announcement that if you'd like to speak, please signal using the raised hand function, and then you can call on them and then mute them if they make an issue and then remove them.
Okay, because I mean, just how they all appeared at once the last time, that's how it happened again, so.
yeah,
Okay, okay, we can go on. I'll message them.
okay.
So Luke, to the mayor's question, what do you think?
well, we can do that. I'm trying to, I think what we're going to need to do though is specify.
Do you want to give this some thought and
I mean, the thing that we need to
include
do
that in
is
the memo
make
to us?
sure that while we are still applying the ordinance in a way that requires registration every 2 years, we charge a fee that is commensurate with that time period, right? So that we capture the costs of operation of the program.
Mhm.
And I think that means that we just need to, in the rental permit duration section, we need to indicate that there's an effective date, effective.
Right.
If we're settling on August 1, effective August 1, rental permits will be for 1 year.
Yeah.
Permits issued prior will be 2, but I think we also then need to add a fee schedule for
both.
the current period of time from now until August
Oh,
1.
that's right.
That essentially will be a doubling of these fees. And then indicate that the fees that are in here go into effect August 1. So that you have an old fee schedule and a new fee schedule tied to the
Mhm.
old rental period and the new rental period.
Mhm.
Does that make sense?
Yeah.
Yeah.
Okay.
Mr. Rock, Mr. Gould, thoughts? Mrs. Pardee?
I like Luke's idea.
I think that would work.
What say you, Mr. Rock?
That's fine. And I just want to see what comes out of what you said with the number of people. That's going to be a deciding factor for me in the end, in terms of the rental registration ordinance.
So we're agreed that this is where we are, and we're going to wait for Mr. McConville to come back with what he finds and what he whatever comes out of the conversation with Ms. Trammell at John Carroll.
Right.
We'll move forward. We'll move forward after that.
Right.
So we should move on to Mr. Zach. You want to take the floor and talk to us about the delight that seems to be structured, getting citizen serve structured and implemented.
Yeah, I mean, as I said earlier, it's not as simple as, downloading, putting the University Heights logo on it and saying, we're
Right.
ready. There's a lot of work behind it. And, if the committee and then council would like to look at, hiring some type of company or additional help to, assist this process, that would be greatly appreciated. But there is a lot of legwork before we are ready for that. As I was saying, when one of our inspectors does a rental inspection right now, they bring back a report and we put that in the system. But then every time they do an inspection afterwards, they take that paper report we print out and they mark on that piece of paper. So even though we have a system saying, yes, there was a rental done on this date, we
None
still
of the
have to,
updated information is in there?
until it's closed out, correct? So, we have, one of the admin staff have to go up to the second floor through Tom's files to find that rental report, see what issues are still there, go back downstairs, take the person off hold and say, this is still what's going on. When can you get this fixed? So there's between, being on two separate floors, working in a house, it's, the separation, which has been great for COVID, but very, very difficult working conditions with, we keep point of sale reports in the master files, but the rentals are in a different file. The building permits are in a different file. There's so much separation because there's just frankly not enough space in the building. We have the basement and our attic space filled with old personnel files from our finance department. And then, on top of that, we have housing plans coming in, commercial plans coming in. There's just a very, very big spatial limitation in our offices right now.
Right.
Where,
Talk to us a little bit, though. I thought you were going to tell us about Citizen Serve and how that's progressing and what's involved in.
Yeah, so after Patrick left, there was no implementation on Citizen Serve. I picked that back up roughly early November. So, we have just restarted the process. We, housing is probably in the 70% range completed. We have a basic portal up right now where you can go and look at, we have all of our information for rental, point of sale, vacant property registrations on the portal. The applications still haven't been completed yet online. Building is maybe in the 20 to 30% completed. As Susan said earlier, we had a commissioner who was not keen on the program, did not frankly work on implementing it. So there's a lot of legwork on top of, not having a director in the department. I spend 6 to 7 hours of my 8-hour workday with the admins, making sure that they, are following the process. Because they've both only been here now 2 months. There's, a lot of if, ands, or buts with every program. How, Franklin is a system where you can do the same thing 5 times and you'll get a different answer every single time. So there's this so many problems of spatial and the system and, a lack of staff between a director and then building inspectors in-house, that it's been very, very difficult to find time to actually work on the implementation of Citizen Serve.
I hear your frustration. It's been that way for a long time. You're thinking, though, that between you and Mrs. Strucker working with the folks you do have, that you think maybe in the next 6 months, you'll be able to have it structured and operating?
I'm hoping, with our 2 new admins, they're, as Susan was saying, they're both very adamant about improving the workplace. They every single day they turn to me and go, why do we do it this way? And I
Set of eyes.
Yeah, it's fresh set of eyes, and I think it's because, Dee and Ruth were doing all they could, and some processes didn't work as efficiently as they could because, the work in that office is frankly indescribable. We bring in a stack of mail this tall every single day on a slow day. Getting through all of that, then phone calls, and then, before COVID, people walking in. There's barely a moment to breathe at points where, Rachel Mullen has told me, there's points where I can't transfer phone calls over to you because all 3 of your phones with 2 lines each are being used.
Thank goodness for voicemail.
Yeah. So, and I understand citizen complaints of, it's hard to get an answer back, or, sometimes it takes a few days. But, I really think all of the staff there is doing everything they can currently to give the best experience to residents, realtors, whoever that they can.
You're all very dedicated and doing the best you can in a really unbelievably and less than ideal situation.
Mayor, didn't you mention, like, I don't know, 3 months ago that you were looking into outsource the building department because we're low on inspectors? Like, maybe that's an idea for the next 6 months for them to get up and running, and then we have everything set.
Mm-hmm.
Well, there's several things that we looked at. For one thing, we've had a CBO and building inspector positions posted both on Boca Neo and on our own website since October. The application pool has been slim. At the same time, we've also taken meetings with SafeBuilt. SafeBuilt is an outside firm that does exactly what you're describing. And we do have a quote from them if we were to go that route. And there are advantages and disadvantages to even a temporary outsourcing of those services. We still have a quote that's valid, I think, and it is still something we could ultimately go back to. We do have a couple of leads with respect to the CBO and inspector positions, though, that I want to make sure we've exhausted before we would return to exploring the SafeBuilt option. So that is something that is a possibility, but remains developing. We have interviewed people for this position as recently as last week. So I don't want to say more in a public context because it is a personnel matter.
Thoughts, anyone? It's a heck of a mess.
I just loved, I know that we'll work creatively together to find ways to be as supportive as we can to staff. It seems like we're in a catch-22 where we have this really awesome software that promises to help ease workloads and increase services, but we can't implement it because we don't have, we're trying to provide quality services and have such full workloads. And I don't
using
know
the system, the existing
right.
system was horrible.
Exactly. And it's like, if we just got rid of that system and got onto the new system, we'd have plenty of time to implement the new system. And so if we can, I don't know if it's an intern or an hourly worker or, something temp or contract, but whatever it is, I know that it sounds like we are all open to creatively working together to find whatever that is. So I look forward, Mayor, to hearing in whenever it's appropriate to share what's going on and what might help. Please let us know.
Oh, thank you. And I appreciate your support. There are a number of things that we have gone through. Brendan has touched on, we are short some personnel. At the same time, we no longer have the personnel there that were actively undermining the changeover. So we are ahead from where we were in that we have people that are committed to the process now in the positions that we have. So that has been a big step forward. The with that, we do have an intern who has been helping part-time also in the building department, Daniel Roach. We did bring him back with the new year to help as well in the department to do some of the things that were described here. So I want to assure you that we are doing things like that. Also, it bears mentioning, I think everybody is aware of it, though we hadn't really had a public type announcement about it. Brendan is the interim manager of the department now, which is one of the reasons why he is here, speaking in extent, but also we are able to hold him out to the community, and he's able to hold himself out to people that we're working with as the manager of the department, who has some decision-making authority and managerial and administrative responsibilities here. And Brendan will be attending our directors meetings internally going forward on this interim basis, as well as attending council meetings to provide updates and reports at council meetings, which is something we have not had in some time. So
Brenda, we really appreciate you stepping up while we're in search of an actual building commissioner, at least doing some of the work that'll help this all move forward.
Thank you. Yeah, I mean, it's been a wonderful learning curve.
I mean, you're very, very young. You're a new grad, so God bless you for doing everything you can. It will be appreciated both now and in the long run.
Thank you.
But what I would also add is one of the reasons Brendan has graduated to the position that he is in is because he has learned this department inside and out in a fairly short period of time. We reassigned him there in October after one of our admins announced her retirement, and shortly thereafter the other admin announced her resignation. And he has, more so than anybody, he has kept this department moving and has kept processes going, and has been essential to learning the positions so that he can train people in the positions. He helped us find the two very good administrative assistants that we have since brought in, who have hit the ground running, and they are exactly as Brendan describes. When I'm over there as well, they're full of ideas, they're full of insight, they're good at troubleshooting, they see what needs to be done. There are plans afoot of all sorts, in addition to the citizen serve implementation, for how things can be done better. They both come from other organizations where things were done relatively well. One formerly worked at John Carroll, the other formerly worked at the Cleveland Housing Court. So, they come in with a wealth of knowledge from other institutions that were large and at times bureaucratic, but then also had to find efficiencies in order to get work done. So, we are the beneficiaries of that experience and finding new and different ways to apply what they know and what they have learned and what they are able to discern from what they bring into what we're trying to do here. They are on.
We have folks that are cobbled together from all sorts of non-related fields, but lots of dedication, and certainly Brandon, the few months you've been doing whatever you've been doing, it's going to help it in the long run.
Thank you.
Couple of months of experience, good experience.
Mm-hmm. Yes. All right. Brendan, was there more that you present this evening? I know you've covered quite a bit of ground.
No, I just really wanted to make sure that the committee and, council knew where we were in this process, the difficulties at every step that we have. And, just to reiterate that we do have a dedicated staff that, wants to see change. The housing inspectors every day come to me and ask, can we look at this? Can we do this? Every single staff member there is dedicated. There is a great team. There's a great foundation in that department.
I'll be anxious to hear how everybody is, progressing with getting citizen serve up and moving, because it's holding up obviously other very germane pieces to what we need.
Absolutely. And, and I don't want to sound doomsday. That's very much, not
It's
my
a
goal
situation
here.
into which you came, you had no control over that.
I just want to make sure that council knows exactly where we are in this process.
All right. I agree with Mr. Gould. I'll be anxious to hear, from you, Mayor, on a regular basis, how this is all moving forward and where we are.
Okay, very good. Well, we'll have regular reports again at council meetings. So that will certainly get the flow of information at a higher
Always
level.
appreciated.
Mhm.
Is that it for everybody? Anything else we need to discuss?
Uh,
I think we're good.
Yeah, I don't have
Anyone?
anything else.
All right. Luke, then I guess we'll wait to hear from you and we'll move forward at that time. You have something, Mayor?
Yes, I do. I do. We started talking about this ACAR thing and it caused a review of our legislation, which was productive, it seems. But one of the things I know we also were needing to look at was we passed legislation without having a penalty provision. And I don't know that we've really addressed that. And that's something that I think we're going to need to, without a penalty or enforcement provision. And we kind of kicked that can down the road. And I don't want to lose sight that we have passed legislation that no longer has any enforcement mechanism in it. And while
I did add some language at the end of the ordinance that does relate to penalty. It's certainly not as beefed up as the ordinance was before, but it does address some of the issues in connection with submitting accurate information and updating that information and indicating that the failure to do that is a violation of the ordinance. And then also just indicates explicitly that the refusal to comply with the rental registration requirements, the refusal to correct building code violations, or otherwise violate, terms and provisions of this ordinance constitute a violation. And then we have a penalty provision that, walks through how violation is a misdemeanor of the first degree and carries with it a fine of up to $1,000 and an imprisonment of up to 6 months. So, there is penalty in here. Also, I just, in looking through our ordinances, and I'm glad you brought this up, Mayor, because we sort of got focused in our conversation on the three unrelated issue. Our ordinances include a criminal nuisance ordinance in 648.17. And, one of the things that the Bedford case, the Bedford settlement brought to light was the idea that you not be implementing a punishment that impacts a tenant that ultimately is based on behavior that the tenant wasn't engaged in, or that related to a disturbance that was caused by some third party other than the tenant. And I think 648.17, which directly references the rental registration ordinance, is probably next on our list for the committee, because what it says is that 2 violations of the criminal nuisance ordinance as determined by the police chief can result in revocation of a rental registration permit. And I think we ought to take a pass through that ordinance in light of the Bedford settlement, and sort of use that ordinance as one of our enforcement mechanisms for this rental registration ordinance.
Okay.
So we do have some enforcement capability currently that I'm very comfortable with, in terms of it both having some potential meaningful impact on the one hand, and not running afoul of the concerns that were being pursued by the ACLU and others in connection with the Bedford case. And then I think we need to move on to our criminal nuisance ordinance and, keep it tied to our rental registration ordinance as it currently is, but perhaps revise.
As a standalone as well.
Yeah.
Okay. All right. Well then, well, it would seem then that there's some more work to do on that, but obviously,
One thing at a time.
right. Okay. Very good. Thank you for bringing that up.
Anyone else have anything else? Mr. Rock, Mr. Cool? No, Susan, we're good?
No,
And I
thank
think
you.
we're adjourned. We'll wait to hear from Mr. McConville, and we're getting there.
Okay.
Getting there. Thank you, everyone.
Thank you.
Appreciate all your
Good
hard
night.
work.
Thanks all.
Good night,
Good
everyone.
night.